All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. We are here today in the SCORZO cases 1 CACV 150730. Each side will have 20 minutes to do your argument. We are recording the argument today, audio and visually. In a couple of days, it should be on YouTube. So if you want to see how you do, you can check that out. Or I should say that you may reserve any time that you want for rebuttal, but you'll have to keep track of that time on your own. We have the clock at the podium for that purpose. When you approach the bench, please identify yourself and your client for the record. We've conferenced the case. We've read the briefs and discussed the case. So we're on board with the facts of this case. So when you begin your argument, please go right into the heart of your argument. And Counsel, you may begin.
Thank you. Good morning, Judge Howe, Judge Winthrop, Judge Thompson. May it please the Court. My name is David Lunn, and I represent the appellants, Linda SCORZO and Suzanne Grabe, in connection with this matter. And we're here today because of the issue of whether or not the statute of limitations ran before my clients filed their claim and whether or not they timely filed a notice of claim. And it's been in my experience before appellate courts, whether it be the Court of Appeals or the Supreme Court, that courts generally attempt to create a bright line rule with regard to certain issues. And that's important because that bright line rule provides guidance to cases going forward, whether or not somebody has a claim or does not have a claim. And I find this particularly true with statute of limitation cases and notice of claim cases. With notice of claim cases, even though there's a statute on point saying this is what's required of you to file the notice of claim, that you have to have facts to support the damages and you have to demand amount certain, we still from time to time see cases that are litigated because one of those factors may not be present. However, the Supreme Court has adopted a strict compliance with that rule. So if you say my demand is $1 million plus attorney's fees, well, that's not good enough. You have to say what the attorney's fees are. And I believe in cases such as that, it is appropriate to have a bright line test. And I also believe in cases of the statute of limitation, it's appropriate to have a bright line test. So for example, if you get rear-ended, you know that there was an accident, you know that you're injured, you have 2 years from the date of the accident to file your claim. Likewise, if you contract to buy 6 widgets, you only get 3, but you already paid for the 6 widgets, you know you haven't received all 3 of the items you bargained for, so you have 6 years from that point to file your claim. That's a bright line test. Similarly, in a medical malpractice case, if you have a tendon that needs to be fixed in your right arm and the surgeon goes in and does surgery on your left arm, you know when you wake up that they operated on the wrong arm and your notice of claim or your statute accrues on that date. And I believe what the trial court did and what the medical board is asking this court to affirm is that for an employee that gets terminated, the date of their termination is the date their claim accrues. And pursuant to the trial court's ruling, that's exactly what the trial court said. The trial court said, as of the date of termination, you knew what facts existed as of that date, so that date is the date of accrual no matter what.
Isn't it isn't it true though, Mr. Lund, that your clients also knew at that time, or they had a good faith belief that the law that was they were being asked to, or the procedures they were being asked to follow, were not legal? Now, whether that was true or not, they still had that belief. Isn't that all that's required?
Well, I think under certain circumstances that's correct, and I think you got to look at what's the reasonableness of that belief and what's the circumstances leading to that belief. So here you have what is presumed to be the medical board making these decisions and making these directives to change the licensing procedures for physicians. And when the employees, Ms. Grabe and Ms. SCORZO, they were terminated, when they were terminated by Ms. Wynn or Ms. Deal, the director and executive director at the time, their understanding was that this was a medical board sanctioned change. And so when you take that into consideration, you look at how boards operate, and when boards consider rule changes, things of that nature, and then you have your executive director and the people in charge then passing down those directives to the employees. For example, and we have two different situations here, and that's why we filed two different briefs. I think we had the brief with Ms. Grabe. At the time, she didn't pursue the claim because she believed at the time she didn't have a cause of action because she believed this was a medical board sanctioned termination. Later, she found in 2013 that the directions of Ms. Wynn and Ms. Deal were their own independent directions and not sanctioned by the medical board. And why did we know that? Because after the ombudsman report came out in October 2013, there was a committee meeting held by the board where they realized what was going on finally, and they terminated Ms. Wynn. And since that time, they've implemented all these changes. They went back and reviewed all the records of all these physicians that were licensed in that time frame to make sure shortcuts hadn't occurred, and if they did, to make sure the appropriate procedures are followed. That's Ms. Grabe's position, is at the time that she was terminated, believing it was a board termination, she was terminated. She wasn't exactly sure why she was terminated. She was questioning procedures, and then she was terminated. With Ms. SCORZO, we have a different situation. And you're right. At the time, Ms. SCORZO believed that they were violating the procedures and rules, and then she was terminated after that. And then Ms. SCORZO went a step beyond that. She did two things. One is she filed a complaint with the ombudsman of Citizens Aid to investigate, and two, she filed a notice of claim. And during that period of time, which the purpose to notice a claim, and when you file the claim, is the parties investigate their claims, the likelihood of success, and the strength of their claims, or whether or not they have a viable claim. And so Ms. SCORZO did exactly that. She actively investigated what was going on. She then, in July of 2012, we get the report from the ombudsman that came back, the same claims that she made in her notice of claim, finding that those claims weren't substantiated, that what the medical board was doing, they were within the power and authority to do.
Well, because why did she need the validation of the ombudsman? Why couldn't she have gone forward with her complaint within the statute?
That's a very good question, and that's what the medical board argues. The medical board argues she was looking for affirmation from her position to go forward with her claims, and it's quite the opposite. I think that she believed she had claims, and then when the ombudsman came up with a report saying they're doing what they should be doing, she went further up the line and talked to the governor's office, who has also said, you know, we've reviewed this, we looked at this, and we believe they're in the right to do it. So then you have to put your...
Well, but I'm not questioning the steps that she took. I'm sure that she felt she was doing what was correct, but what we're concerned about with the statute of limitations is the time between the event and the filing of the complaint, and the whatever happened in between doesn't affect whether the statute of the limitations is complied with, right?
In some regard, that's correct. And I think this is, when you look at the cases, this is a case that has different facts and circumstances than cases we've seen. This is a case where actually somebody filed a notice of claim within the required period of time. It's a very short period. You have 180 days to file the claim. She filed it right away. Contemporaneous with that, she was also doing an investigation. She was preserving the claim by doing that. The filing of notice of claim is preserving the claim, saying, here's my claim, I'm preserving this, so if you don't accept my claim, I can file a lawsuit or not file a lawsuit. That's provided at that point.
But you have to file your lawsuit within the statute of limitations.
You do, unless that gets to the whole point. We look at whatever the tolling statutes apply to and whatever the discovery rule applies to, and you look at, and when you look at the notice of claim statute itself, it says you knew or should have known you had a claim and the cause of the claim. And so when you're doing your investigation, you can look at something and think you have a claim at first, and you investigate that claim, and then you get other rulings and other decisions that impact your decision of whether or not you have a viable claim. And so it comes down to the issue of, when that decision is made to file or not file a lawsuit, does a person believe they have a viable claim? Because as you know, if you don't believe that your claim is a meritorious claim and you file a lawsuit, you can be subject to sanctions for doing so. So it was actually a
Is this a subjective test or an objective test?
It is a subjective. It's what the reasonable person, a subjective, reasonable person would do at the time. And so when you look at the notice of claim as knew or should have known, that is an objective test of what should that person knew or should have known. And when there's facts relating to that issue of what they knew or should have known, our position is that when there are questions relating to what they knew or should have known, or whether their belief was a good faith belief or not, those are questions of fact properly decided by a jury and not by a judge on a motion to dismiss.
Well, counsel, it sounds to me like you're reading into this statute a condition that the potential plaintiff needs to know the validity of their case, as opposed to what the statute says, which is you have to know you've been damaged, or reasonably know you've been damaged, and know or reasonably know what the cause of that damage is. Now, here it seems to me, I can see an argument that in this case, both of your clients knew they had been damaged because they were both their employment was terminated, and secondly, they knew how that happened because they refused to follow the directives of their superiors. Maybe I'm just taking too literal look at this language in the statute.
Well, I can address that, Your Honor, and I've had cases before walking into my office under those same circumstances where the plaintiff gets fired and one person is working for Maricopa County School District, and they look at, this is a right-to-work state, and if you disagree with somebody or what they're telling you, they have the right to fire you. You can walk in the office one day and they have the right to let you go. And the question is, and that causes you damage no matter what. Any date you're terminated, you're damaged because you no longer have a job and you no longer have income. So the question is, was that wrongful? Was that a wrongful termination? And that's the issue where the subjective mind would say, is it reasonable to conclude that this individual didn't believe that the termination was wrongful or did believe the termination was wrongful? And that's where it comes to the factual situation and when the jury needs to address those facts to see if somebody's belief was reasonable or not. And a good case for that is Walk v. Ring. Walk v. Ring is the lady who went in, she got all of her teeth redone by the dentist, and they ground her teeth, and she got TMJ and it hurt, and she knew she was injured, and she knew that the doctor probably did that.
But then in that case, there was an element of concealment by the dentist.
True, and I believe whether the court in Walk v. Ring analyzed both issues, and there are both issues whether or not that should be told because the knowledge was remanded on that cause, and it was also remanded on the cause of fraudulent concealment. So it's both issues that the court determined the trial court got wrong.
Can we really, should we consider and apply Walk, or should we distinguish it on the basis of the fact that that's a common law accrual case as opposed to here's a case against a government entity or employee, which is controlled by the statutory language on accrual.
Well, I think that statutory language, if you have statutory language, any claim, and that's kind of my point. If the court's going to say that if there's a statutory claim, there's no accrual, I don't think that's the law. And I think when you look at the Supreme Court cases in Gus versus Prudential and in the Walk v. Ring, Gus v. Prudential, before that time, nobody believed that the tolling applied to contracts. And so there's statutory provisions that you still have to know. The element of the tolling provisions under any claim is, did you know about the claim and did you have a reasonable belief that there was damage was caused by the person? So, for example, if you look at if my client would have been walking down the road and got hit by a city dump truck, she would have still had to comply with the claim statute at that point and filed against the city. So, but she would have known that that's the city hit the dump truck. And here you're looking at, okay, I know that you fired me, but I don't know if that was wrong. And the question is it reasonable for me not to know that it's
wrong? But under your example of the dump trucks, so the person knows they've been injured because they were hit by this truck. They know, they know what the mechanism of injury was. They don't know whether that driver was negligent or not, or whether there's a valid cause of action, but it still triggers the notice of claim and the accrual of the statute of limitations.
Well, I suggest my clients are more like the patient who goes to the doctor and they get a surgery done and the doctor leaves a sponge in. It may hurt right away, but they may not know if they left the sponge in, there's negligence until a few years later. And this few years later here was in 2013 when the Ombudsman report came back, and they found that Ms. SCORZO and Ms. Nguyen didn't have the authority to do what they were doing. They concealed that from the medical board, which if they would have known that at the time it was concealed for the medical board, then they could have filed a complaint. But when you have a situation where you have a vetted procedure change, and this isn't the reasonable person as a judge or a lawyer. You're looking at the reasonable person as you're sitting in this situation where you're working for a board and you have supervisors on the board believing that the actions of the supervisors are sanctioned by the board. And if it's not, and that's what the board found out, they were concealing, Ms. Lynn and Ms. Deal were concealing what they were doing, what they were instructing them to do. So it wasn't sanctioned at all. So the claims for us are against the state of Arizona because the board's a non-dual entity.
So if someone is injured, say, if a bystander is injured, say, in the course of a police chase, if do they have to investigate and determine whether the police were following, the proper chase procedure before they can, sue the police department for the injuries that they suffered because of the car chase?
I think, Your Honor, that some of that issue, for me, when you look at a claim like that, you're looking at the negligence of the person who hit them and whether or not the being on probation was reasonably foreseeable and what duty there was to supervisor. So I think there's all sorts of issues that go into that analysis as far as whether or not when the claim tolls. But I think that when you look at it this way, I think when you have an accident that's not your fault, you know that there was an injury and know it wasn't your fault. You know somebody else was responsible. So that's not the situation where you can sit there and say, I don't think somebody else was responsible for this, but that I consider my rights to not do anything about it. On the other hand, when you have a situation where you're terminated and it may or may not be your responsibility, and then you, with your investigation or otherwise, determine that, well, it probably was my fault because I was insubordinate, I didn't follow instructions, and then later you find out, you know what, the exact same things I was complaining about they were doing wrong. So they did retaliate against me, and they fired me because I was questioning those, and I had the right to do so. And that's when the distinction between that type of a claim. And so I guess at this time, if there's no further questions, I'd like to reserve the rest of the time for rebuttal.
Sure, counsel. Thank you.
May it please the Court. Good morning, Your Honors. Rachel Bacalzo-Remus, appearing for the State of Arizona. With me at council table is my colleague, Assistant Attorney General John Fry. The issue before this court is whether the plaintiff's claims accrued at the time of termination in 2011. Accrual occurs when a plaintiff knows or reasonably should know the facts required to establish the elements of the cause of action asserted. The Employment Protection Act, or the EPA, has two primary elements. That is protected activity as defined by the statute and a termination as a result. There is no dispute. The plaintiffs knew these facts at the time of termination. Therefore, their claim accrued at that time, and it did not matter whether an independent third party at a later time agreed or disagreed with their case. That is the time the cause of action accrued. The Arizona Supreme Court, in the Gus Rosenfeld decision, said that a cause of action accrues when one party is able to sue another, and that means when a party knows or with reasonable diligence should know what is the factual basis underlying a cause of action. As this court said in the Dubé versus Likens case, to make that determination of accrual, we must examine the elements of the claim asserted. The plaintiffs have asserted two different types of legally protected activity in support of their claims. First, that they opposed the new licensing procedures, and the other is that one reasonably believed that there was a violation of law in implementing these procedures and disclosed that to the supervisors. So refusing to violate the statute and disclosing a reasonable belief. They admit those facts in their complaint. They argue them in their briefs. There's no doubt. Ms. SCORZO said she complained about the legality of the procedures at a staff meeting in October of 2011, and that she was terminated the day after she called the Arizona Department of Administration to file a complaint. And she did more than that. After her termination, she went to the Arizona Ombudsman, filed a complaint about the legality of the procedures, and as the court already knows, she filed a notice of claim. Ms. Grabe, on the other hand, did not file a separate complaint, but she says in her complaint and acknowledges in her brief that she knew immediately upon termination that the reason she was fired is because she refused to follow those new licensing procedures. She thought that it was insubordination, and she was on notice at that time to investigate whether she actually had a cause of action or not.
So, counsel, notwithstanding all of that, Mr. Lund's arguing that we've also got to look at that part of the reasonableness analysis under the statute is that we should look at sort of the overlay of Rule 11 on possible sanctions for bringing a frivolous action or a case that's not a claim that is not based upon in the law. And he's arguing that part of the reasonableness needs to be evaluated by the jury as a question of fact, because you've got a report of I don't even know how we characterize the ombudsman, whether it's a state agency or a quasi government office, but shouldn't we take that into consideration?
No, Your Honor. The Arizona Ombudsman's opinion is an opinion that has no impact on plaintiff's ability to bring an Employment Protection Act claim. It's not an element of the claim, and as this court knows, we must examine accrual by looking at what is required to establish the elements. The plaintiff argues over and again that both plaintiffs argue that they had to establish that a violation of law occurred. That is nowhere in the statute. It is not in the plain text, and as this court acknowledged just a few weeks ago in the Harper versus State opinion, you can bring an EPA claim without the necessity of establishing that an actual violation of law occurred. Whether the Arizona Ombudsman agreed with the plaintiff's position or not, they had a claim, and that claim accrued at the time of termination. Your Honor, there's no dispute of fact over that. We don't reach the reasonableness analysis because it would not be necessary to submit this issue to a jury. No reasonable jury could find differently. They admit that they had the facts required to establish the two primary elements, that they disclosed their belief that the new licensing procedures violated Arizona law. They told their supervisors, and they were terminated promptly upon those disclosures. That is all they need to establish a violation of law.
Even if at the time of that occurs, they, I assume, wrongly believe that the terminations were proper?
Yes, Your Honor. For example, Ms. SCORZO's complaint is very similar to the facts in the Little versus State opinion, and in that case, the plaintiff brought a wrongful death and medical malpractice claim. But also, before bringing that complaint, the plaintiff authorized a local reporter to file a medical board complaint against the doctor. The plaintiff argued in opposition to summary judgment that the claim didn't accrue until the medical board issued a report and findings that the doctor had engaged in illegality. This court disagreed. The court said that the fact that you authorized a complaint to be filed, you had knowledge of the facts required to establish malpractice, and you were on notice to investigate your claim. That's very similar to what Ms. SCORZO did in this case. In fact, the notice of claim is a statutory requirement, so it more strongly than the Little case demonstrates that she had the requisite information to know that she may have a claim and that she had an obligation to pursue it. It was her choice not to do so.
If the medical board in that case had decided that the doctor had acted properly, would that have made her complaint unreasonable?
Your Honor, the issue, though, whether it was reasonable or not, is there were no facts about whether it was reasonable. The court said in that case that the medical board's report did not determine when accrual happened. So therefore, there was no disputed issue of fact. Plaintiff had enough information to trigger accrual in that case when she authorized the reporter to file a complaint. Similarly, Ms. Graby, although she did not file a notice of claim and she did not file an ombudsman report, her case is very similar to the facts in the Thompson versus Pima County case. That was an automobile accident case in which the plaintiff was on notice that the county controlled the road where the accident occurred and was on notice to investigate whether there was a claim. That plaintiff had enough to move forward at that time, and that's when accrual happened. The plaintiff in that case, on a notice of claim accrual issue, argued that they could not bring a claim until their accident reconstructionist actually issued a report and found negligence on the part of the county. This court disagreed and said, you had enough information. You didn't need to wait for a report by an accident reconstructionist to give you the information you needed to bring a claim, and therefore the court concluded that accrual happened before the accident reconstructionist claim. Ms. Graby is in a similar situation. She did not file a complaint like Ms. SCORZO did under the Little analysis, but she admits that she had enough information to file her complaint. What does she admit? That she disclosed that there was a problem with the legality of these licensing procedures. She refused to follow them, and she knew that she was terminated as a result of that. How she interpreted the meaning of that was something she was entitled to do, but once you're on notice of the facts, you must investigate, you must determine whether you have a claim. Illegality and a violation of law is not required, so their choice to rely on an opinion that has absolutely no impact on their ability to pursue an EPA claim was their decision to make, but it was wrong. It doesn't change the fact that accrual happened at the time of termination. And once the clock starts, it didn't stop because the Arizona Ombudsman concluded there was no violation in 2012, nor did it restart in 2013 when the Arizona Ombudsman reached a different result. Plaintiffs are relying on facts that do not establish the essential elements of the claim, and they are irrelevant to the issue of accrual. The plaintiffs also argue equitable estoppel should apply, but it doesn't apply to a case like this where the plaintiffs have the information needed to bring their claim and they choose not to. They argue that the defendant concealed facts that they needed. Well, we know that's not the case. We just have to look at the plain text of the statute and look at cases like the Harper decision to see readily a violation of law does not need to be established. So the reason they say they waited is because they needed to establish a violation of law. But if that is not required to actually file a lawsuit, then it's irrelevant. The claim still accrued at the time of termination and not after, regardless of the opinion of the Arizona Ombudsman. And that is an opinion. It doesn't have any binding effect. And furthermore, there are no facts to establish that there was some kind of fraudulent concealment. It's simply a conclusion. No reasonable jury could find that the plaintiffs, based on their own allegations in the complaint and their arguments in their briefs, that they were missing something they needed to know in order to file their lawsuit. As this court said in Little, you don't have to have all the information that you might prefer to have for accrual to occur and to file your complaint. But that doesn't change the fact that accrual happens when you have those facts. And in this case, there is no dispute. The plaintiffs had the information they needed at the time of their termination, and therefore their claims accrued at that time. If Your Honors have no further questions,
Thank you.
I ask the court to affirm the Superior Court's judgment. Thank you.
Thank you. Counsel, you have 2 minutes, 50 seconds.
Thank you, Judge Howe. There's one thing, a couple of things. First of all, I don't believe the Little case is like this case at all. I mean, the Little case, their argument was that we're waiting for an accident reconstructionist to do the report before we filed a claim. And then we find out that it was. Here, when you look particularly at Ms. SCORZO's case, after she was terminated, she filed a notice of claim. She did what she's supposed to do. She filed a notice of claim to pursue her claims. Then, through the process of investigation, and the Ombudsman report came out, and I don't necessarily think that the emphasis should just simply be on the findings in the report. I think when we look at the employee when they're terminated, what facts did they know at the time? What knowledge did they have of what was really going on, what the medical board's position was on that? They heard Ms. Wins and Ms. Deals. And then when you get the Ombudsman report, the report not only comes to its determination, there's all sorts of factual analysis within the report which necessarily goes into the investigation of one's claims. And so if you look at the report, you see the analysis, and based upon that analysis, you see the claim differently. You realize, well, everybody else is still working there. They're still functioning. This report says they didn't do it wrong, that they had the authority to do this. The governor's office says, yes, we review that. They have the authority to do this. At that point, if I was in that person, as a reasonable person, would think I don't have a viable claim, that I should have done what they told me to do, and I should have moved forward, then I wouldn't have been terminated. And that, Your Honors, is exactly what we're talking about. There are the bright line rules. There's the bright line rules that should apply. But there's also cases like this case, like the Walk case, like the Gus Roosevelt case, where they say if there's factual questions about the reasonableness of somebody's position, those questions must be resolved by a jury. And that is exactly why we're here today, Your Honors, is to say that with all due respect to the trial court, we think that they got it wrong. We think that the issue of accrual, the issue of concealment, are issues a jury should properly decide, because it comes down to what's the reasonable basis of their opinion, and could a reasonable juror agree with that position. And if so, like we found in these other cases, then there would be a cause of action. The cause of action wasn't stale because it expired pursuant to they didn't timely file it. And it's those factual issues that are properly resolved before the jury. So respectfully request that the decision be reversed, and this case be remanded back to the trial court for further action. Thank you, Judge
counsel.
Howe, Judge Winthrop, and Judge Thompson.
Thank you. We appreciate your arguments today. We'll take this matter under advisement, and we stand adjourned until the next case. Thank you.